Hello, everybody. Good afternoon. Welcome to our last installment of this summer's BMSC Research Seminar Series. I'll just give a quick introduction of the Bamfield Marine Sciences Center while people are trickling in from after their lunch break. The Bamfield Marine Sciences Center is located on the west coast of Vancouver Island within the traditional territories of the Hawaiian First Nation. And we are a not-for-profit registered Canadian charity, as well as a shared campus of the University of Alberta, University of British Columbia, University of Calgary, University of Victoria, and Simon Fraser University. So this BMSC seminar series is a long tradition at BMSC. Generally, it happens on site, but this year we're going online. And we use it as a great opportunity to learn from experts in our community about the new discoveries being made in various fields of marine science. It also supports our vision to create an open, collaborative, and approachable community of scientists at BMSC. If you like what we're doing and want to see more or get involved, please visit bamfieldmsc.com. So there will be a Q&A section at the end of this webinar. Time free to just type any questions you have in the Q&A section located at the bottom of your screen. If you just drag your mouse down, if you're in Zoom, it should pop up. There's also a chat box that you can use to talk to panelists and other participants, but to save your questions all in one section, please type them in the Q&A section. And yeah, once again, just do this anytime throughout the seminar. Great, so today's speaker, I'd love to welcome Deborah Curran, and we'll be learning about fluid jurisdiction in marine territories, Indigenous rights and legal pluralism in Canada. So Deborah Curran is an associate professor in the Faculty of Law and School of Environmental Studies, as well as an executive director of the Environmental Law Center at the University of Victoria. Deborah's work focuses on governance, how we make decisions about the environment, and who has the authority or thinks they do to make those decisions. As you might imagine, this work always involves examining Indigenous authority within the Canadian state, environmental baselines, and how law messes up ecological health. Deborah is also teaching the only ongoing interdisciplinary field course in law in Canada, and currently does so in New Channel territory at the Bamfield Marine Sciences Center with the support of the Hawaiian First Nations. So this course is happening as we speak, and thank you for taking the time out of your course here to speak to everyone about this. I'm just going to unmute your mic and ask you to start your video here. Welcome, Deborah. Thanks for joining us today.
My pleasure. And it is, as you mentioned, we are just mid-field course right now. And so it's not only a strange experience to be teaching a field course online, but later perhaps you'll see in my background that in fact I, just like Luke does, I have the marine chart of the territory up. And so it reminds us, I guess, and sort of on an ongoing basis of where all of us, me and the 28 students, would like to be. We'd prefer to be in New Channel territory and interacting with members and leaders of the Hawaiian First Nation in person, but they have been so kind to continually be involved with us throughout the course as we do it remotely. So I'm a little bit off model in that I am not a scientist. So I'm a social scientist and a lawyer by training in colonial law. My interest and my interaction with the Bamfield Marine Sciences Center is that I teach field courses that are embedded in a place. And it helps all of the students who take the course to better understand how to address complex socio-ecological issues. And so the first 5 years of the field course were taught at the Hakai Institute in the Central Coast in Wekino and Heiltsuk territory. And then the next 5 years of the field course will be taught in New Channel through Hawaiian territory with the support of the Hawaiian First Nation and the Bamfield Marine Sciences Center. And the intent is that as an interdisciplinary course, we come together, people with backgrounds in biology and ecology or political science or sociology or law. And then that's really what it takes. It takes a complex ecosystem of people to be able to address these really complex socio-ecological problems in order to move towards better outcomes for our territories. So with that background, I wanted to acknowledge that I am coming to you from the territories of the WSÁNEĆ, Songhees, and Esquimalt peoples. And the spirit with which I do my work and how I live and play is to always uphold the authority and the knowledge of those communities in whose territory I am a visitor. So with that introduction, I am going to hopefully talk for not very long about something that's a little different for those of us who are interested in marine science or marine communities from what we normally think about. And I'd like to talk a little bit about what we broadly call, in a settler sense, jurisdiction. So by jurisdiction is who is making decisions and who has authority for making those decisions. And I think it's interesting to contemplate that question, in particular in our marine environments in Canada, because we have very rapidly evolving and interesting arrangements between Indigenous communities and the colonial state that are really changing the way in which things happen, in particular in landscapes. And that is an acknowledgement by the provincial government of Indigenous authority. And this is not occurring as much in marinescapes. So it's interesting to plug into why that is. And it's important for me to give a little bit of context. This work really comes out of my interactions with places through the field course. So as I taught the first field course from 2011 to 2015, really the interactions that I was having with the communities and with people like, staff from the Department of Fisheries and Oceans, as it was called at that time, having these conversations about what actually does occur within this region and who is making decisions about the environment and interactions with the environment. And so this has led to several publications, the most recent one being with Gagvi Marilyn Slett, who is the chief counselor for the Hiltzik First Nation, relating to extractive governance and Indigenous economies, and how those two things, the way in which colonial law or state law really is in conflict with the way in which Indigenous communities see themselves carrying out their economic relations or the relations with the environment that lead to the fundamental basis of their economies. Really has all come together through the field courses that I've taught, and then also through the client-based work that the Environmental Law Center does. So the ELC is a clinic here in the Faculty of Law at the University of Victoria, and people and First Nations bring projects to us, and students then put in thousands of hours a year on those projects, and they go back out to communities. And so it's through the Environmental Law Center that I see a lot of the interactions of what is going on around the province, and which then of course informs the kinds of things that I'm thinking about from a research perspective. So turning back then to this notion of fluid jurisdiction in the marine environment, what I'd like to do is just unplug a little bit this sort of formalistic notion that we have if we're located in state law, so in federal law from a colonial power, this narrative of federal marine jurisdiction. So most of us would say, who has authority or who is responsible for making decisions about the oceans. And most of us would say, well, the federal government does, and certainly Fisheries and Oceans Canada takes a large role. And I'd like to just point out that it has always been more complex than that. And it is becoming increasingly complex, which is a positive thing, because we know from an ecological sense that complexity sometimes often breeds more resilience, and then also breeds interesting and new outcomes. So I'd like to challenge us to think in that way, think in ecological terms as we consider these, what are sort of structures of jurisdiction or authority in our marine environments. So first of all, to turn to the narrative of sort of the federal government as the holder of marine jurisdiction, we see that from the Constitution Act 1867, and the Constitution is our sort of our uber law in Canada. It's our primary law that says who gets to do what, or who is responsible for what in terms of the Canadian state. And we see that under 9112, the federal government were the winners of sea, coast, and inland fisheries, and also navigation and shipping. And so even if shipping has an impact on provincial or municipal or Indigenous authority or activities, the feds are still responsible for those kinds of conversations and for regulating and those activities. We know, though, that that is just one of the stories that are told, although it is an omnipresent story because it is, we are in a settled state, we're in an era of colonization, and certainly settler law or state law is omnipresent, meaning it's the one that we can interact most readily with, it's most tangible to us. We know that there are many, many different stories about jurisdiction or authority or responsibility for, or this is the way we do things throughout British Columbia in our marine environment. And so the many, many different coastal communities and Indigenous communities have and have always had complete governance and authority structures around the way in which the environment responsibility is taken for it and management occurs within that marine environment. So I've only put a very few here. There's many, many more. I didn't want to point to any one specific nation or way of interacting or being responsible for the environment, but there are lots of different things that we have access to, in particular through a lot of the work that researchers associated with the Bamfield Marine Sciences Center are pulling out in partnership with their Indigenous co-scientists or partners in science. And so there's lots of different ways that we see this authority is exercised within that and predating that federal structure. And very recently, we also see the Hatwiya Forum on Fisheries of the New Channel Nations exercise their authority in a very overt way, in a way that we would understand in terms of actual, are we fishing, are we not fishing, or quotas and that kind of thing. And so as an expression of the Hatwiya Forum, they are saying, at least in 2017, we're saying that there simply is not enough herring, and therefore they will not have a commercial fishery in their territory until the herring populations have recovered. So this is an ongoing conversation, but I wanted to put this in here so that we can sort of chew on management practices or the exercise of authority that also speaks to whether to fish or not, in a way that, if we're familiar with more of a state-centered fishing regulation, I guess, this would resonate with us. And certainly other communities that I've worked together with on the field course have taken this approach as well, typically in front of or before DFO has put in restrictions or regulations. For example, the Wekino First Nation, before DFO cut back on certain salmon fisheries, the Wekino were limiting what they were taking from the Wannock River because they were seeing such a drastic decrease in coho populations and in other populations as well. And as we know, the exercise of inherent or traditional authority and Indigenous laws, and what in fact the state or the federal state, the exercise of federal authority has done, is it has led to a significant amount of conflict in certain areas. So these are just a few examples, so a few headlines from some relatively recent actions around choices that have been made by the federal government around fisheries management, and Indigenous nations exercising their responsibility and their authority within their territory, and having a different view about what actually should go on within those territories and in those marine environments. And there's many, I should underscore that Indigenous communities have always exercised this authority in a variety of different ways. We see perhaps a bit more interaction or willingness on the Canadian state, so perhaps the federal and provincial governments, to discuss these issues. because of instruments like the United Nations Declaration on the Rights of Indigenous People, which is an international instrument and which then establishes or sets forward a number of different concepts around territory or responsibilities around territory. In particular, the principle of free, prior, and informed consent. So the fact that Indigenous communities should be able to have some measure of control and autonomy, which is expressed partially through the language of free, prior, and informed consent. And then more recently, last fall, we see the provincial government enacting the Declaration on the Rights of Indigenous Peoples Act that talks about the convergence or bringing provincial law into alignment with the declaration, so the UN Declaration on the Rights of Indigenous Peoples, and also providing mechanisms by which the province can enter into agreements with Indigenous communities or First Nations so that those First Nations can either exercise consent for proposed projects or activities, or they can actually take on what would have been previously or looked at as provincial decision-making authority. So with that backdrop, sort of the, at its bare or most overt look at, if we ask the question about who has jurisdiction in the marine environment, what's most evident to us is that the federal government takes responsibility for it. But as I've tried to problematize just in the few comments before this, is that in fact, Indigenous communities have always had authority and have always been exercising that authority in different ways, whether or not we as settlers, most of us, have access to the way in which that authority is exercised. And so what I want to do is just then, before I go into two very specific examples of the way in which jurisdiction is changing and Indigenous communities are exercising their authority in a way that interacts with the Canadian state. So I'll use the example of the Health-Sex response and interaction with the Nathan E. Stewart diesel oil spill in their territory. And then I'll also use the example of the First Nations in the Broughton Archipelago, what is known as the Broughton Archipelago in Kwakwakwa territory. So the northern part of Vancouver Island, Johnson Strait, between the mainland and Vancouver Island. So in that area, how they have a consent-based process for the continuation of fish farms being able to operate in that territory. Those would be the examples. I just wanted to get back to some basic concepts around legal pluralism and then around Aboriginal rights so that we come to the understanding, or at least what I hope is at least unpacking a little bit this notion of federal authority or sole responsibility for our marine environment, and really come down to demonstrating how when there is a conflict about what's happening in the marine environment, we have what we call a conflict of laws. So we have a conflict of equally valid legal orders in Canada that are operating parallel and at the same time, but they might not have mechanisms by which they resolve those conflicts. So starting off then, what is legal pluralism? We think that we generally operate within, from those of us from the West that haven't dealt with Quebec all that much, we treat ourselves as if we operate within a common law system where we can access laws that are made by the legislature and administered by the government. But in fact, even from simply a settler or colonial perspective, we engage in a legally pluralistic way in Canada because we have both the civil law in Quebec, which is a different legal system, and the common law in most of the rest of Canada. And so that's what we mean by legal pluralism. There are multiple legal orders acting at the same time, and they are interacting, and whether or not they have an ability to interact is another question. I would like to throw into that as well what makes us so much more interesting and complex in Canada is that we have multiple Indigenous legal orders that also continue to operate equally legitimately as settler regimes, if not more legitimately. And they also have established relationships and rights to the environment and governance systems that, as I said, either may have ways to address or deal with settler law and settler governance processes, or may not. I'd also like to point out that these, the Indigenous legal systems and Indigenous authority predate settler legal systems. So they were around before Confederation, before colonial societies got here, and continue to operate on their own terms. So they don't need legitimacy through settler law in order to continue to be and to operate. They do have legitimacy through settler law. We don't need to go into that, how that occurs. But the fact that they are and continue to operate on their own terms speaks to their inherent authority. And so we get then both state or colonial law and Indigenous laws operating in the same space at the same time. A moment in colonial law that occurred was in 1982, where we amended our constitution, repatriated and amended our constitution. So remember, thinking back to the original comment that I made about our constitution that divided up authorities between different levels of government, and the feds were the winners of seacoast and inland fisheries and navigation and shipping. Well, in 1982, we had the 1982 Constitution, we had the addition of Section 35. And if I asked you all to say, what does, if we think about Aboriginal rights, what does Section 35 say? And many people would say Section 35 protects Aboriginal rights, Aboriginal and treaty rights. But in fact, it doesn't protect Aboriginal and treaty rights. The language is that it recognizes and affirms. So this is a colonial statement or a state law mechanism by which there is an acknowledgement in Canada that in fact Indigenous rights, Aboriginal rights, and treaty rights, they exist and they continue on. What that has resulted in is we don't, the rights to fish, rights to hunt, rights to carry on cultural practices, in certain circumstances, the right to trade, so economic rights, those are largely subsumed within a consultation framework, meaning if a provincial or federal government is going to approve an activity in a traditional territory, they're required to consult with the Indigenous community. And if that project is going to have an impact on those Aboriginal rights, they have to accommodate those rights in some way, but often the activity can still move forward. So there's the Indigenous communities who have authority within those spaces vis-a-vis the state governments actually don't have an ability to say no when we're dealing with Aboriginal rights in most circumstances. And this then leads to these kinds of conflicts that I alluded to before. So there's a whole lot of case law around Section 35 about what it means, this recognition and affirmation of Aboriginal and treaty rights. And the Canadian courts, which again are a colonial construct, have been quite clear that the purpose of Section 35 is to bring about the reconciliation between Indigenous societies and settler societies, and that is best done then through negotiation. The courts have not used the consent word, so perhaps I shouldn't have put those two, reconciliation and consent, in the same sentence. What we're seeing though is sort of reconciliation in the past 5 years. Those kinds of conversations have very much turned towards Indigenous communities calling for consent about the kinds of activities that occur in their territories. And then also so consent through either environmental assessment processes or simply consent about the kinds of activities that they will permit. And so ultimately then, before going into my two examples that I wanted to give to you about shifting jurisdiction in marine territory, when we have a state government, such as the province or the federal government, saying, yes, there can be an activity within a traditional territory, and an Indigenous community is saying, no, that activity cannot occur here, or that much of the activity cannot occur here. So for example, herring fisheries at this point in time on the west coast of British Columbia generally are opposed by the Indigenous communities. We have what's a conflict of law. So the Indigenous communities are invoking their own responsibilities and their own laws and understanding toward their territory to say no. And the state government is invoking its own laws in order to allow projects to go ahead. So just to create a more complex tableau, I guess, about who is responsible or has authority in the marine jurisdiction, two examples that are sitting at top of mind for me right now and that I'm thinking about and interacting with are these of the Heiltsuk's interaction with the Nathan E. Stewart, or what happened to them in their territory when the Nathan E. Stewart ran aground and spilled a lot of diesel in their territory. And then also the agreements between the nations in the Broughton Archipelago and the provincial government about fish farms. So when the Nathan E. Stewart ran aground, the Heiltsuk insisted on being part of the emergency response team, so that small group of people that are coordinating the response effort, the emergency response effort. And what they then produced out of that is the report on the far left of your screen, the Heiltsuk investigation report. And what it was is their reflections on the first 48-hour response of the emergency marine management system in Canada, or emergency response system, off the west coast of BC. And they documented their experience and how, in fact, it did not uphold Heiltsuk law, and it was ultimately detrimental to Heiltsuk people themselves, as well as to the territory. They then went on to do a couple of very interesting things that really speak to them demonstrating their authority and their jurisdiction. They have used the term jurisdiction, so not all Indigenous communities use that term. But Heiltsuk have made, or I guess, used their authority and jurisdiction in an outward facing way such that those of us who are outside of the community could interact with it or see how they were choosing to exercise that authority in response to the Nathan E. Stewart spill. And so one way that they have done that is that they put forward a proposal for an Indigenous Marine Response Center. And they proposed to the federal government that, in fact, because of their experience with the Nathan E. Stewart, it was proven that the marine emergency response system was inadequate. And therefore, there should be an Indigenous-led emergency marine response ability in the Central Coast. When that was put forward, it was not accepted by the federal government, or wasn't funded by the federal government. I'm not sure where it sits right now, but that's an interesting and very overt exercise of authority, saying we're responsible for our territories. All of the Indigenous communities in the Central Coast are responsible for their territories. We're able to do marine response in a better way than occurred, and here's our proposal for moving that forward into the future. The second thing, and these are only two examples of many things that the Haishluk have done in response to the Nathan E. Stewart spill, but the other thing was that they instituted an Indigenous legal process, a Heiltsuk legal process based on their gvilas, or their laws, and they did an assessment of the behavior of the federal government, the provincial government, and the owner of the vessel. And they then had an adjudication on what all of those behaviors meant. So the spill itself, and then the actual response of the different responsible authorities. And then they rendered a decision in Heiltsuk law about the impact on Heiltsuk people and territory, the impact on their responsibilities for having responsibility for that territory and authority in that territory. And then they set out a decision about what the federal government needed to do to make it right, what the province needed to do to make it right, and then also what the owners of the Nathan E. Stewart needed to do in order to be able to give restitution to the Heiltsuk, clean up the territory, and then also be able to come back into the territory at all. The final thing I'll just draw your attention to, which is a little bit more in the language that we might understand if we are steeped in an understanding of settler law or state law is in the lower left-hand corner. This is the style of cause to an action or an action in maritime law that the Helsing have filed against the feds in the province, and also the owners of the Nathan E. Stewart, asking for compensation for the impacts in territory. Oh, this is the style of cause as well. This second example I wanted to draw your attention to, just as a really contemporary and interesting example of exercise of authority, inherent authority, and also as it very specifically interacts with state authority or the exercise of state authority, is the long-standing issue of fish farms in the Broughton archipelago. So there are upwards of a dozen fish farms in that area, which has fantastic flow. And for, as long as they have been there, the nations have been asking for them to be removed. They have continually challenged their presence in their territory in court. And many of you will be familiar with the science of Alexandra Morton, who has, sort of systematically studied a variety of different things, but is well known for the studies around the impact of sea lice on farm fish on wild salmon, and then also the impact of infected fish, I guess, or infected smolts being put into the marine environment. So this is a photo I just took a month ago. We were having a family paddle up in that area. And so this is one of the fish farms around the Village Island site. So what occurred was back in 2018, there was an agreement signed, or an MOU signed, between three of the nations, so Quixotenac, Hawamis, and the Namgis and the Mamalilikula. And they agreed that the provincial government would not reissue or would not renew the land-based tenures for the fish farms unless a number of conditions occurred, the most prominent being that any fish farm that was to carry on operation in the territory had to have the consent of the First Nations in whose territory it operated. So this was the first time that we have seen an overt consensus-based process that was supported by the provincial government, or such a change in their willingness to acknowledge Indigenous authority and address some very long-standing issues in this way. I'm not saying it's the first time that there has been a consensus-based process, but as an outcome, but this is the first time that it was sort of put out there in the world right off the bat, and beforehand, sort of before the decision was made or the agreement was come to, that it would be a consent-based process. And so over the course of a couple of years of negotiations, so you had the agreements between the nations and the provincial government, and then you have an agreement between the fish farm companies and the First Nations as well. The way the wording goes, and if you read the totality of the agreements, is that first, the Department of Fisheries and Oceans needs to be satisfied that there will be no adverse impact on wild salmon stocks by the continued operation of the fish farm. So the fish farm on a fish farm by fish farm basis. And then the second thing is that the fish farms must have a negotiated agreement with the First Nation. So they have to have the consent of the First Nation in whose territory they operate. There are a couple of other conditions. So there is an Indigenous monitoring program that will be set up that will sort of oversee what is occurring in and around the territory and on the fish farms, and a few other things. So the province and the nations put forward a bunch of joint recommendations, sort of the upshot of which is to close, ultimately phased in over a 5-year period, to close 10 farms, and then 4 could remain operational if they are able to secure consent of the nations in whose territory they work. So I appreciate that I'm speaking to a very interdisciplinary audience. So I hope that my explanations have been, if not clear, you've at least been able to, they've resonated with you in some way, and that I've used language that you're able to relate to in your own personal experience. What I just wanted to leave you with are a couple of thoughts. If we turn our brains back to how we interact with the marine environment, and this notion that at least what we interact with is federal authority over the marine environment. I hope what I've done today is just to point out that that presumed authority or jurisdiction is actually much more complex than what we normally are able to touch, and that it's our responsibility in whatever territory we are to really figure out how that authority, or at least try and come to some understanding about how that authority plays out in the marine environment in a way that respects those Indigenous legal orders, Indigenous legal processes, and management practices that are inherent to those communities and are occurring at all times. So I just wanted to point out that within the Section 35 of the Constitution Act 1982 framework, the need to consult with First Nations, that framework that's been set up through the colonial courts, really doesn't get us to consent or an acknowledgement of Indigenous authority. So that's why I've put that term there. Consultation is not consent. And in the few examples that I've used this morning, and I could have drawn on many others, what we presume to be federal authority in the marine environment is certainly not absolute. It's changing, and in particular, it's changed in the last 5 years quite significantly. And it certainly will be and continues to be negotiated between nations or groups of nations and the various levels of government. And then finally, let's dig back into our ecological brains, or our brains that connect with the functioning of the natural environment, and just pull up some principles that maybe will resonate with us that might also stand us in good stead for socio-ecological systems. So rather than relying on the one set of laws or management systems that we would call the federal government, let's embrace diversity in all its various ways. That would be to make our marine environment so much more complex if we're working with and acknowledging Indigenous authority, which will create much more resilient relationships with the environment, much more resilient management systems, and also new forms of governance that will hopefully help us to solve some of these complex problems as we move forward. So thank you all for listening to my research and my current thoughts, and I'm happy to take any questions that you have.
Thank you so much, Deborah. That was really informative, and it was just kind of the exact kind of seminar that I was looking for to get me caught up to speed a little on just how everything works. I did an environmental science undergraduate that finished in 2010, but I don't believe, sadly, any of the courses that I took, or that it was mandatory to do an environmental law course in Ottawa. So anyways, I've been really anxious to participate in your course here. Maybe while people are considering questions and going to type them into the Q&A, so I'll just remind everyone to type them into the Q&A if you have them. I have a question for you. I'm wondering what the biggest challenges are in terms of law for everyone who's, all of these like legal pluralisms that are working, given the different timelines of environmental disasters or things that are sort of damaging the environment, and then the timelines of how long sometimes it can take to move something into law. And how do people sort of overcome those challenges, given that there could be like a 10-year difference between, figuring out if fish farms are bad and then finally getting them closed?
Yeah, that's such a great and huge question. So what I'll do is I'm going to approach it using the lens of scale. So both geographic scale and then also time scale. And this is something, so appropriate we should be doing a place-based course at BMSC at this point in time, while we're all sitting in our offices or at home doing this online in this COVID era. But that is something that we talk about all the time. What is the appropriate scale at which to address management of ecological processes or relationships with ecological processes? And so generally law does it very poorly, or management as set up through law, settler law or state law does it quite poorly, because it doesn't react or it doesn't respond fast enough to actually deal with threats on the horizon. So why do we have a herring collapse? It's sort of a combination of permitted overfishing, meaning the state allowed the overfishing to happen, lack of understanding about the herring life cycle and actually how they interact, very large ecological herring units, so not small scale enough that one could get a sense or a really accurate or truly accurate sense of what's going on for that particular sub location of herring or population of herring. And this, I have a science background, but the things that I'm saying are not coming from me or my reading. The things that I'm saying are coming from interacting with the Integrated Resource Management Department of various First Nations and their observations about why things are failing around them in their marine territory because of the decisions that are being made by the federal government about management and allocation. And so oftentimes we're looking then to put structures that will respond better to ecological processes that requires a much longer time frame of assessing or evaluating and expecting or understanding impacts. So the example that I often give is that the Great Bear Rainforest Agreements for the Central Coast, or the area of the Central Coast, the coastal temperate rainforest, while not marine-based, so they're land-based, but one of the ecological thresholds or standards that was set as part of those agreements between the provincial government and the First Nations there is that there will be an 80% return to old growth or range of natural variation of old growth in all ecotypes over a 250-year time frame. And so by giving that time frame, it's acknowledging that there needs to be a whole bunch of restoration that occurs, as well as putting in forestry practices that will allow that restoration to occur within those various ecotypes. So time scale is super important, and likewise appropriate geographic scale or ecosystem scale for addressing these kinds of issues.
Right, such a complex thing. Yeah, and thank you for that answer. I've got a question here from Natasha. Hi, Natasha. I'm wondering about the role of things like the Broughton Agreement in pushing the envelope of acceptance of, I'm sorry, this screen is too far away from my face. Okay, I'm wondering about the role of things like the Broughton Agreement in pushing the envelope of acceptance of consent-driven processes more broadly. What kind of legal instrument is it? Do they carry the same kind of weight as case law in establishing precedents? There's several other follow-up questions which I'll read sort of after, but I don't want to load you with too many questions right here.
Okay, yeah, that's a great question. Thank you. So typically these kinds of consent-based agreements, and there's a whole bunch in the province. The Haida have a lot. There's agreements right now to enter into watershed planning processes with five nations in the Nicola Valley, also with Cowichan tribes. So there's a number of examples across the province. They are called government-to-government agreements. So they exist. They are the agreements between two different societies, as we would understand. They're not international law necessarily, but they have that kind of interaction. It's between a government entity and another government entity. And they typically deal with things like, what is the process? What are we going to do together? What is the process? And what is the timeline for this? They're typically not that long, so they'd be from 2 to 5 years usually, and they agree to undertake something. They exist sort of outside of case law. So I've only once seen a case that implicated a government-to-government agreement very specifically, and I'll go into that in a second. But the idea is that instead of using the courts, which are a colonial construct, and actually don't solve problems. They say either you win or you lose. So they are a mechanism by which two government entities agree to go down a process of joint decision-making together to come to an agreement or some other resolution to solve very specific problems like water shortages or fish farms destroying wild stocks and that kind of thing. So the one case that we actually look at in the course that I'm teaching right now that actually references the importance of government-to-government agreements is in 2015 and 2016, a number of the nations on the coast, so the Ahousaht and others in New Channel Territory, as well as the Haida, challenged the federal government's permission for a commercial herring fishery. And in the 2016 Haida case, part of the reason the court granted the injunction to the Haida and said there should not be a commercial herring fishery, among other reasons, so there were a number of reasons. One of them was that the federal government had entered into multiple government-to-government agreements with the Haida around the management, both marine and terrestrial, for Guayahanas National Park. And they said, look, if you, dear federal government, if you make decisions and you enter into processes and build trust and relationships and a working relationship with an Indigenous community through a set of agreements, these government-to-government agreements, even if it's a different arm of your government, meaning this was Parks Canada and the Council of the Haida Nation, you cannot make decisions over here that are unilateral and that then threaten these relationships. So to me, that's a super fascinating statement out of colonial courts because they acknowledge that there's something special about agreeing to build relationships and trust in a working relationship through this mechanism of government-to-government agreements. And they don't want other decisions made by different arms of that state government to threaten that goodwill and that relationship.
Great. And the sort of follow-up to that question is, do you think advances in these kinds of arrangements with forward-thinking provincial leadership will help to push the envelope of federal willingness to engage with these same issues in similar ways?
Yeah, so that's a great question too. So that's kind of in the realm of politics that I'm not much really qualified to comment. What I will do is I would just comment from my observation is that it takes definitely political will. So whoever is sitting in the state government needs to be willing to engage. And then it also takes pushing from the outside quite steadily, which Indigenous communities do all the time. And so we see a little bit more opportunity right now because both the federal and the provincial governments have said that they would like to work towards the implementation of the United Nations Declaration on the Rights of Indigenous People. We've certainly had eras where the provincial government's willing to engage and the federal government isn't at all. And so you get this sort of massive disconnect about what's being negotiated across landscapes and in sort of terrestrial territories, and then what's happening in the marinescapes.
Great. Well, that was 2 questions, which is more than the last 2 seminars we've had. The last 2 times we had a 0-question audience. So thank you, audience, for engaging and taking the chance to answer questions. I believe Deborah's contact information is on the UVic website if you ever wanted to reach out, if you just thought of something later. Deborah, thank you so much for joining us today. I'll just check the YouTube channel really quick. I'm seeing no questions in this chat either. So I guess we get to end early and try and enjoy the sunshine before the rain comes.
Okay, well, thank you. And thanks to BMSC for hosting these and for keeping us together as a broader community. Much appreciated.
Oh, it's our pleasure. Yeah, thank you so much. And we look forward to meeting over Zoom again soon, but then also in person very soon as well, hopefully, as soon as we can.
Okay,
Thanks
bye-bye.
again. Goodbye, everyone.